Let me ask you this. If your business is developing software or designing algorithms, do you know how well your intellectual property is actually protected? Copyright protection arises automatically in Australia, but if you rely only on that, you may be leaving your most valuable digital assets exposed. I'm Damon Murdoch, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're seeing is actually my AI avatar speaking from a script that I've personally written and approved. In this video, we'll go beyond the basics of software copyright and explore advanced strategies for protecting software and algorithms under Australian law. When it comes to software and algorithms, the starting point is copyright. In Australia, software code isn't treated as something separate or exotic. It's actually protected the same way as books or written works under the Copyright Act. That includes both the source code, the human readable code, and the object code, which is machine readable. Copyright arises automatically as soon as the code is written. This was recognized by the High Court in the case of Computer Edge v. Apple and reinforced in Microsoft v. Business Boost. In short, copyright protects any original expression of instructions that makes a device perform a function, regardless of the programming language or format. That broad definition captures software components and algorithms. Now, copyright is the foundation, but it's not enough on its own. Businesses need to take proactive steps. First, documentation. You should maintain detailed records of who contributed to the code, when it was created, and what parts of the software or algorithms are original. Second, technical safeguards. Beyond access controls, businesses should deploy robust anti-piracy and anti-circumvention measures. Courts recognize the importance of these safeguards. Tools like CodeMeter, SafeNet Sentinel, or Denuvo can help prevent reverse engineering or unauthorized copying. Third, legal notices and tailored licenses. Copyright notices should appear in your code and your user interfaces, and your end user license agreements should clearly set out ownership, permissions, restrictions, and prohibitions on reverse engineering or redistribution. Many companies have enterprise agreements with customers, but forget about end user license agreements for end users like employees and contractors. That's a gap you don't want. If your software or algorithms are misused, Australian law offers several remedies. Beyond damages, which compensate for losses or profits, courts can award additional damages for deliberate or flagrant misuse, especially where someone circumvents a protection measure. You can also seek injunctive relief, which is a court order requiring the infringing party to immediately stop using or distributing your software. However, there are some limits you need to understand. Copyright protects the way your idea is expressed, not the underlying idea, function, or algorithm. That means if someone independently develops software that performs the same function without copying your code, they may not be infringing. That's why trade secrets or even patents may be better suited for protecting algorithms. Regular monitoring and auditing of your IP assets is critical. You should be checking customer use, watching the market for similar products, and keeping comprehensive records of your code. And don't rely on copyright alone. Layer your protection. That means NDAs for staff, contractors, and partners, strong terms of use for customers, and trade secret protections for algorithms and proprietary code logic. Finally, think internationally. Copyright is recognized globally under treaties like the Berne Convention, but each country has its own nuances. If your software is used outside Australia, You may need a broader international IP strategy. Software and algorithms represent some of the most valuable business assets today. Copyright protection is the starting point, but it's not the end of the story. The real strength comes from combining documentation, technical safeguards, licensing, and proactive management to maximize the commercial value of your digital IP. At Leo Lawyers, we work with Australian businesses, founders, and developers to put these strategies in place. If you'd like to learn more about how to protect your software or algorithms, you can contact us through the details in the description box or visit us directly at leolawyers.com.au. Thanks for watching. See you next time.